All right, so we're back, and first part we talked a little bit about commercial litigation, and first time I'm doing Facebook Live without handlers helping me out, and I did not realize so many questions were being asked. I often am doing when I do videos, I do them with supportive staff. It's Saturday morning where I am in Toronto, and so I do not have people on hand. But I am going to do a bit of a Q&A, and I'm also just going to talk a little bit about the politics side of law. And so I mentioned commercial litigation previously. I'm now a member of Parliament. So for those who don't know about Canadian politics, we have provincial governments, regional governments, we have municipal governments, city governments, and we have one national government, the federal government, and I am part of the federal parliament, the House of Commons in Ottawa. And so about half the year, 26 weeks of the year, I am in Ottawa where the House sits, and we debate laws, and we have committee work, and I'll get into the nuts and bolts of that. And just want to make sure that I'm doing all this right after the last one. So I have been elected for 2 years. I was elected in October of 2015, and I am a member of the Liberal Party of Canada. Most people would be familiar with our Prime Minister, I think, Justin Trudeau, who is also a member of the Liberal Party. And we have over 180 members of Parliament who are from our party, and we have 338 seats total in the House of Commons for all parties, and so we have the majority, and so we form government. I'm not a member of government formally. I am a backbencher and a parliamentarian, but I'm a Liberal MP, and so I'm supportive of our government and the work of our government to date. It's a bit of a funny role sometimes where you are obviously supportive, but unlike a lot of jurisdictions, because I've met a number of MPs from around the world, we don't have a hard and fast whip. And what does that mean? So there's a chief government whip, and their job is to ensure that members of parliament are supporting their particular party's agenda. But one of our key promises in the election was to do things a little bit differently and to improve our democracy even more, and to ensure that we enable members of parliament, including Liberal members of parliament, to better represent their constituents by disagreeing every once in a while with the central party if necessary. And we said that we would only demand consistent voting records and compliance and agreement on human and charter rights issues. We don't want to have our members vote for unconstitutional legislation or violate rights. We would only whip it on budget matters, so financial matters, and confidence matters, so we don't want to throw the government back into, or we don't want to throw our system back into an election at the expense of our Liberal government. And we ensured that we would be voting together on election promises. If I knocked on a door, and my team knocked on and reached out to 120,000 doors, so every door 3 times, I've got about 40,000 households in the riding. We made a lot of promises, and I'm going to stand up and vote for every single one, and every Liberal MP who made those promises is going to stand up and vote for every single one. But that leaves some room for disagreement, where new issues arise and new debates occur. And so we have given freedom to MPs to represent their communities, and we don't always have to agree. So there have been any number of times, I think 20 or so times out of I don't know, maybe 10% of the time, I stand up and I have a different view than some of my colleagues, certainly than the government, and I exercise the democratic rights on behalf of my community, and to ensure that I'm standing up for them. And at the end of the day, I'm a Liberal member of Parliament, but I ultimately represent Beaches East York. So the conflict is simply, you're representing your riding, but you're also a Liberal MP, and obviously you want to be supportive of the government's agenda. You're a team player, but you're also a member of Team Beaches East York, and reconciling those can be difficult, especially when, at the end of the day, our system is fundamentally designed for government and then Parliament. to hold government to account. And so one of my roles is to hold the government that I support to account. And doing that requires a lot of thoughtfulness sometimes. So how do we make laws in Canada? I wanted to get at that a little bit. So the government oftentimes introduces legislation, and the government oftentimes introduces legislation, and that will be de facto first reading. You can think of it has to go through 3 readings. That's how we think of it. Okay, and so first reading is usually pro forma for the most part. Second reading is where the substantive debate occurs, and what it means is there are usually a number of days in the House of Commons, and we have full days where we debate the legislation. What that looks like in practice here in Canada is you have members stand up and give 10-minute speeches. Usually they're 20-minute blocks, but we share them 10 minutes and 10 minutes with another member. And you get up and you give a 10-minute speech about why you support the legislation, issues you might have with the legislation, why you don't support the legislation, what changes need to be made for you to support the legislation at committee. And really the purpose of second reading is to debate. Yeah, you can get into the details, and you can say, I hope this gets fixed and I hope this gets fixed. At the end of the day, your support should rest on whether you agree with the object or purpose of the bill. Because you're going to have multiple rounds of debate, and the reason you have multiple rounds of debate is because the first round is for the fundamental purpose of what you're trying to achieve through the legislation, or what others are trying to achieve through the legislation, and then it goes to committee to clear up any language, to hear from experts, and I'll get into the nuts and bolts of that. And then the third reading is to adopt it as legislation. And so at that stage, you really want to make sure every word you are agreeing with as much as possible. But at second reading, you're talking about the idea more generally, and it's important to keep that in mind. So we get up and we debate the idea at second reading. We then have a vote, and when we vote, I'm not sure how it works everywhere, but when we vote, there are 338 of us, and they roll call us, and each time they say our name, if we're supportive, and they say everyone who agrees with the bill, stand up, and you would have to stand up when they roll call you, or they'll stand up and then they'll say your name, and if you disagree, you wait for them to say, and all people who vote no, and then you stand up and they'll call your name, and you sit back down. Every vote, as a result, takes about 10 to 15 minutes because everyone's standing up and sitting down at various times, depending upon voting yes and no. If you abstain, you can stay sitting, although there are no recorded abstentions. So if you're not there, it's the same as if you abstained and you sat in the House and you just stayed sitting. As for the formal record, you could, of course, write a letter or write an article explaining why you abstained, and as opposed to why you were traveling or something like that. So that's second reading, and then it goes to committee. And committee is made up of 10 members of Parliament, and we have, for every minister that we have this is perfect. We have a standing committee or a parliamentary committee that matches the portfolio of that minister. So we have a minister of health, we have a standing committee on health. We have a minister of defense, we have a defense committee. We have a minister of the environment and climate change, and we have a environment committee. We have a minister of natural resources, we have a natural resources committee, and on and on and on and on. So the reason for that is because you have a minister, and we've got about 30 ministers that are formally the government, and they introduce legislation, and they've got a bunch of staff, and they've got departments that work to build up that legislation and work out the details and consult and engage in some cases, very broad consultations with experts and the community more broadly, and they put their best foot forward through that legislation based upon what they want to accomplish as far as government objectives are concerned. And then it gets to committee. If it passes second reading, and government legislation I've never seen it not pass second reading, given government's got the votes, and committee then has an opportunity to hear from civil society and to hear from academic experts and to hear from concerned citizens if they have the bandwidth to do so. Usually it's advocacy organizations, and concerned citizenry has their voices heard through a particular outlet, like an NGO or an advocacy group, and the and specific sometimes you'll hear this legislation should be scrapped entirely. More often you hear this should be amended, this should be amended, that should be amended, that should be amended, and so so the committee can then introduce amendments to the legislation to fix up particular language. And they can also introduce some new things, but you can't introduce anything that's not within the scope of the bill. And so the committee can't just throw everything they want in it. They have to stick within the four corners of what the government originally intended, but they can tweak things to fix it. And so that's important to keep in mind as well. And then once it goes through committee, and there's a voting process at committee to adopt, we call it clause by clause, where we literally go through every clause and line of the legislation and adopt it and or amend it. And every member of the committee has an opportunity to put forward amendments. And then where amendments are put forward, we vote on those amendments. And where the amendments are passed and then the clause is adopted as amended, we ultimately pass. Very rarely do we decline we send the bill back and say we shouldn't pass this. That really, and I'll get to private members' business, but we'll stick to government legislation for now. We would amend the legislation or not, and send it back to the House, and then the House would again debate it at third reading. And at this point, you're debating the whole legislation, the minutia of it, the object of it, and everything in between. And we have another vote. You stand up and they call your name and you sit back down. And if there are sufficient votes to get it through third reading, in our world, we have two chambers. So we have the House of Commons, the elected chamber, and then we have the Senate, the unelected chamber, the appointed chamber. And so ours is 338 seats, the Senate's a little over 100, and the Senate then goes through the same three readings, so they do the same thing. First reading, second reading, committee, and third reading, and the various stages of debate, almost identical to the House, and they are more deferential in many ways because they're not an elected body. And where they do suggest that changes be made, they can, if they amend the bill, it comes back to the House, and then we have to adopt it as amended by the Senate, or send it back to the Senate. And there, you could imagine a situation where the Senate amends something and sends it back, and we reject the amendment. We send it back to the Senate, and the Senate amends it again and sends it back to us, and back and forth and back and forth and back and forth and ping pong. Typically, it does not happen that way, simply because of the roles of these institutions in our world, because we have more democratic legitimacy in the House. What you'll typically see is we pass a bill, the Senate amendment kicks it back to us, and we either adopt it as amended or we refuse the amendment and send it back to the Senate, and the Senate usually defers in that instance to say, we've done our job, we've recommended a change based on the evidence we heard, and if the House, the elected body, is unwilling to consider that, we will defer to the decision of the elected body. And so that's the gist of making law. Now, there are small ways of tweaking that process through. You can introduce motions in the House to seek unanimous consent and move things through faster. That rarely happens, but occasionally does. There are small ways that you can move to send a bill to committee at first reading instead of at second reading. And if you send it at first reading, then the committee has much larger scope to change the bill and to make amendments. That rarely happens, and that only really happens when the government is really seeking all-party consensus on a bill and wants to make sure that all parties have an opportunity to hash it out, and that it's not just little changes are being made at that point, but that the opposition parties have the potential and the opportunity to make more substantive changes. And then there's oftentimes opposition motions that seek to amend things in the House. Those are almost always made for political purposes, and if amendments are going to be made by opposition members, I have only ever seen them, I think, be made in my last 2 years. I've seen them made at committee, but not in the House. And beyond the government's legislative agenda, you have private members. So I'm technically a private member because, as I say, I'm a Liberal member, but I'm not a member of the government. And so every private member is kind of an odd situation. you get elected, you have your name thrown into, if you're not a member of cabinet, a member of the government, or a minister, you have your name thrown into a hat. Not a hat, I think it's a box, and they, run everyone's names around the box, and then they pull them out one by one, and that's how they get the list for private members' business. And so you basically have the first 30 people on that list get to introduce legislation that will be debated and voted upon. You have two rules. You cannot tax, and you cannot spend money. That taxing and spending money, that's for the government to do, and they do that a lot. But as a private member, you are unable to do so. And so you have to think of an idea, and usually a smaller idea. The smaller ideas are usually the most successful. You don't always need to pass legislation to be successful, though. Sometimes you just want to raise a topic for public awareness, and that can be very successful, too. But if you want to pass a piece of legislation, oftentimes it's a very narrow topic. It'll garner consensus across the aisle on a relatively small issue. And you introduce as a private member, and it's much and the debate is very restricted. So we only have 2 hours of debate, and then we have a vote. Then it goes to committee in the ordinary fashion, and so and it also has to go through the Senate, and away we go. And the Senate can do the same thing. So the Senate can introduce bills and laws, but they can only do so. So the Senate can introduce. Here, one sec here. Bills and laws, but they can only do so. Here we go. Okay, so I want to make sure I get the comments here, and so I'm just pulling I'm doing both my job and my staff's job here. Okay. Where was I? Oh, the Senate can introduce legislation as well, and so the Senate can introduce legislation that, again, doesn't spend money and doesn't tax. Okay, so I wanted to make sure I answer questions. And so let's get at some of these questions in the comments. What are the things that need to be considered while drafting a closing argument? So fundamentally, you are wanting to summarize the key facts and key evidence that the judge ought to consider in making his or her determination. And you want to make sure I talked about reverse engineering the case. You are setting out the key evidence and the key legal arguments so that it necessarily follows that the judge should decide in your favor. And you're doing you don't want to spend any time talking about extraneous detail. You want to really get I mentioned point first writing. I think it's point first submissions. You want to be very clear, concise, and direct as much as possible. How can I start my hearing in any criminal case before a judge? So I have no idea the answer to that question. I never practiced criminal law. As I mentioned, I practice commercial litigation, which is really business law, but business law in the litigation context, where businesses are fighting one another, or an employee is suing a company, or shareholders are debating or arguing, I would say, about what each of them respectively deserves. Occasionally, I dealt with family law or estate matters, but very, very, very rarely. Closing argument comes at the end of the trial. What should you try to accomplish? Okay, so as I mentioned, you want to, as much as possible, just hit the highlights of your main evidence and your main arguments, and why the judge ought to decide in your favor. Okay, and let's go back here. Here we go. Okay, so we've got what made me interested in politics while I was a commercial litigation practitioner. So I studied politics and law at Queen's and at Oxford. And when I was at Oxford, it occurred to me, I read mainly political philosophy and constitutional law and legal philosophy, and a lot of the writers spoke about the role of courts and the role of legislators, and had a dim view, in some cases, of some people had a dim view of legislators, and some people had a dim view of courts. But for the most part, there was this sense that both are a noble enterprise that fit together, and they're necessary complements. And it really struck me the importance of the legislatures. I mean, I'd always thought maybe I'd be a judge one day, and that was what I might work towards, and I'd be a lawyer and work towards that public interest role of the judiciary. But the fact of the matter is, there's a lot of writing about the importance of legislatures and the nobility of that decision making, and really how it's more important in many ways because of the impact it can make on people's lives. I mean, judges can't spend money, and so judges make a great impact on individual cases. But through, the Canadian government spends $330 billion a year. It makes a massive impact on people's lives across the country, well beyond an individual dispute. And the Canadian government sets rules on protecting the environment and climate change, sets rules on how we best address poverty, and what are the particular programs and the specifications of the programs that we can address poverty with. And so these are big questions and important questions, and it's governments that tackle them, not courts. And so I was drawn to those ideas, and then I was struck that the writing I was reading was about the importance of legislatures and the importance of the political process, and yet people don't trust politicians, people don't trust politics oftentimes. And so how do you reconcile those two ideas of how important it is and how little people trust it? And when Justin Trudeau came along, he wasn't Prime Minister at the time, and said he wants younger people to get involved in politics, and he wants people to represent their home communities and to be voices for their communities in Ottawa. I thought, what's the worst thing that can happen? That sounds like a great idea. I'll give it a shot. Okay, what else do we have? In commercial litigation, who are the parties? Is it national or international? So you can have international commercial arbitration and litigation. I never did that kind of work. Mine was always within domestic disputes in Canada, and we both use courts, commercial courts, civil courts. In Toronto, there's a specific commercial list with more experienced judges in commercial matters. But we also used arbitration. That's oftentimes retired judges, and the advantage there is oftentimes it can be a bit more expensive sometimes, in some ways, but it can oftentimes be faster. And so we went through that process as well in shareholder disputes. What else do we have here? The speciality in commercial matters and how these difficulties can be handled, or for commercial litigation, which are the main concerning parts. So the bread and butter of commercial litigation is breaches of contract, I would say. And then that's supplemented, certainly our practice was supplemented with the following. So you have breaches of contract as the core, shareholder disputes, we saw them all the time. Occasionally we would see particular areas like franchise law, but the core of it was breaches of contract, shareholder disputes, and fraud. And then it was also supplemented with some employment law as well. Please give us an example in tort in commercial litigation. So an example, we had a case of negligence comes up all the time, and so we represented a couple of clients who were fighting with their real estate agents and with developers because their homes had been poorly built and or sold to them without adequate disclosure in their view. And so you have the argument there is oftentimes negligence. You also see negligence. We had a case where there was it was a technology issue and breach of privacy potentially, and again, you're talking potential negligence. I didn't argue very many negligence cases, though. I mean, most of it was breaches of contract and fraud matters and shareholder disputes. And fraudulent conveyances happen quite a lot in our world, where you're dealing with people who have gone bankrupt or are trying to avoid their creditors, and they claim bankruptcy, and then it's forensic auditing and accounting in many ways of tracking what are these people engaged, and that's the discovery process, getting them in front of you, asking questions. There was one case where my boss asked tough questions of one individual, and we discovered that there was a hidden credit card, and that led to all sorts of other discoveries once we received the records of that credit card. And so fraud often goes hand in hand with commercial litigation as well, especially in the context of bankruptcy. Who are the parties in commercial litigation? It depends. I mean, you've got a plaintiff and a defendant, and it can be any number of people. It can be an employee suing a company for breach of contract and wrongful termination. It can be a company suing another company for a breach of contract and failure to deliver, on failure to meet failure to perform effectively the duties under that and obligations under that contract. So there are, in the case of shareholder disputes, we talk about the oppression remedy, and we talk about where you have a majority stakeholder. So say you own 60% of a company and I own 40%. Well, you have the power to make decisions, and you take decisions to dilute my stakeholding to 2%. Well, you've just taken what was 40% and completely undermined it down to 2%. And if you did it for the specific purpose of enlarging your portfolio and diminishing mine, well, I can sue you for that conduct, and I can have you buy me out, or I can probably buy you out, depending upon the election that I want to make, because of your unreasonable conduct. But absolutely, I can get out of that arrangement. I can get back to where I was if you've acted unreasonably in diminishing my shareholdings. Okay, what else do we have here? Always takes an extra bit of time when I have to read the questions myself here. All right. Which kind of rules are your country's courts following regarding the interpretation of statutes? We're a common law jurisdiction, so much of the case law that we read in our law schools comes from the United Kingdom. And the statutes, though, you're talking 3 levels of government, as I mentioned. So you're looking at national rules, and in our Constitution there's a division of powers as between our federal government or national government and our regional provincial governments or territorial governments. And so there's sometimes overlapping jurisdiction, but mainly there are carve-outs. So property and civil rights are for the provinces. So provinces are responsible for most of the domestic statutes as a result, and the federal government is responsible for interprovincial trade and trade and commerce more generally, and certainly for international matters. And I could go down the list of different things where criminal law, for example, is ahead of federal national power. And so on the commercial litigation side, you are almost exclusively dealing with provincial statutes, except insofar as you have federally regulated companies, or you have federally incorporated companies, in which case there's similar rules on the books, but they're just in different statutes. So when I talk about franchise law, that's the Arthur Wishart Act in Ontario, is what we call it, but it's the Franchise Act, and it's a provincial statute. The Ontario Business Corporations Act governs Ontario corporations, which is the bulk of the corporations operating in our province. We have employment law that governs employee and employer relationships, and that's a provincial act. And so you have case law that is persuasive. So case law that is binding from the Supreme Court. You have case law that is persuasive from other jurisdictions, usually the UK and United States and other common law jurisdictions, if they're on the same point. Academic articles can be persuasive too if they summarize and speak to the issue and summarize the case law from other jurisdictions or other provinces. I should mention provincial case law is also persuasive. It's not binding. So where our Ontario Court of Appeal has determined something that's determinative, but if the BC Court of Appeal has determined something, that is only persuasive. And so other provinces, even if they're Court of Appeal, appellate level courts, they are not binding on our practices in our region of Ontario. But it's a compilation of different statutes, but fundamentally we're a common law jurisdiction. So if the UK has done something for a very long time and first principles have developed over a very long period of time, we're in all likelihood following that trajectory. How can I win a case when I have weak evidence? So my colleagues and I, when I was practicing law, would acknowledge all of the time, you can be the best advocate in the world, and you can, but you'll lose all the time, because at the end of the day, facts matter, evidence matters, and you can't, no matter how good of an advocate you are, you can't take a losing case where the evidence is clearly where it is, the law is clearly where it is, and the two together mean you don't stand a chance. And that just is what it is. And sometimes clients want to fight it, they want to delay, they don't want to pay out right away, and so you just have to do your best to put your case forward and put your pleadings forward and go through the motions, but you're not going to win. And usually it's pretty clear if you're going to win or you're going to lose, and then there's that middle ground, and the middle ground is usually quite large because people don't usually want to litigate if the answer is so clear. So if you have weaker evidence, or you've got some weak evidence and you've got some strong evidence, that's much more likely. And there, as I mentioned, I mean, you want to put your best foot forward and put your best evidence forward, but you can't ignore, you can't shuffle under the rug the weak evidence and hope the judge doesn't see it. So much of this is about building credibility as an advocate before the court, and you're going to be back before that court many times, not just on this one case, and you cannot be seen as an advocate who is going to be less than forthright with the court. And so you have to manage bad facts, but don't ignore bad facts. And you have to, one example would be where you have a bad fact. If there's a related good fact for you, you put the two together. And so you, when the judge is reading about the negative fact, they're also reading a good fact at the same time about your client. So if your client has done something negative, well, if they have also got a lot of positive community service, you might say, the client has a lot of community service, but it should also be acknowledged that they did this. Well, now if I'm reading that, I now have a mixed view rather than a bad view. Whereas if you don't mention that negative conduct and you just said, oh, he's got a lot of great community service, and the opposing counsel then says, well, yes, Your Honor, but he's also done this, counsel's going to then, I think, or the judge, I think, in most cases, will place less of a regard or less of an emphasis on the evidence you put forward because you haven't been completely forthright. And so manage the bad facts as much as possible. And there are a number of techniques, and as I say, I'm happy, this kind of advocacy itself, I could spend much more time on, but it's don't ever ignore bad facts. I think I've hit all the questions here. Let's see if there are other... Yeah, okay, so I think I put all the questions here. If anyone else has a question, please put it in the comment section now, or forever hold your peace. Hey, buddy. You want to say goodbye? Say goodbye? So this is McKinley, and it's a Saturday morning, and it's now 9:15. So with having answered all the questions, as I say, I'm happy to come back anytime, but I'm going to sign off now. So say bye-bye.